On immigration. Here today with me is Ryan Wilk. He is a partner with our firm. He's been with us for 10 years now,
10 years.
if you can believe that. And he does everything I-140 and adjustment of status. He's the managing attorney for our immigrant visa department. So all the I-140 petitions, adjustment of status filings, anything to get to the green card. He handles all of that, so he's practically seen every single RFE you can think of when it comes to I-140 petitions and the 485 applications. So today we have some updates for you. We wanted to talk about what we're seeing with I-129 receipt notice delays and what this means for people who are using that auto extension. You get that 240-day automatic extension of your work authorization, but if you don't have a receipt, how does that work? We also have some updates on the state workforce agencies. This is a very important part of the PERM process and what's going on there and how is it going to impact PERMs that have not been filed yet. We also have new prevailing wages that started July 1st. Different SOC codes, different wages. This happens every year and we're going to update you on that. And lastly, we've been hearing reports of issues with using this G1450 form, which is kind of a new thing, but it allows people to pay certain application filing fees by credit card. So we'll talk about that a little bit. So let's start off with this I-129 receipt notice delays, and how does that impact your ability to continue to work, Ryan?
Okay, so over the last 2 or 3 months, I'd say we've learned as an office, as well as speaking with attorneys and our liaisons in the field, that USCIS is experiencing a significant delay issuing receipt notices. And so in some instances, we've seen those delays anywhere from 4 to 6 weeks. Now, generally, any delay in a receipt notice is going to be a headache. But when we're talking about maybe using that receipt notice for an automatic extension of work authorizations, particularly with regard to I-9 compliance, what do we do? And so the largest issue that we are seeing with the receipt notice delays is, or just generally, when you're filing your H-1B extension, you're typically given a 240-day extension, an automatic extension of the work authorization while that H-1B pens. Now, that receipt notice, that acts as the I-9 evidence, the documentation of your I-9 compliance. So when you're without that receipt notice, how do you demonstrate to the government that you are in compliance? Well, luckily they have provided us some guidance. The first thing that we want to show is a copy of the form I-129 that was filed. So I would just call that the I-129 file, a copy or proof that you've paid the filing fee, so a copy of the check and hopefully maybe proof that that check has been cashed. And then third, proof that the petition was mailed to USCIS. So that can be the FedEx mailing, the US Postal mailing, something showing those three things: the copy of the I-129 that was filed, a copy of the fees that you've paid, proof that you've paid the fees, and then proof of the mailing. And that will act as I-9 compliance documentation until you get that receipt notice in hand. We are seeing them maybe 4 to 6 weeks delay, and so if you are in that period, keep these documents on hand. Once you get the receipt notice, go ahead and take those three things out, put the I-797 receipt notice in, and you should have everything that you need to be compliant. So that's on H-1B extensions. Now, we are seeing some delays on EAD extensions. The same provisions, the same guidance isn't applying to by USCIS with regard to EAD extensions. And so typically when you're filing your EAD extension, before it expires, you're going to be given an automatic 180, now I think it's 540, a temporary extension of that work authorization. But only the I-797 receipt notice for those EADs will be proof of the I-9 compliance. And so if you are in that position where you don't have the receipt notice and the EAD that you filed upon has now expired, you need to wait until you at least get that 797 receipt notice in hand before you can maybe consider yourself I-9 compliant.
All right. Also, we're seeing some weird issues happening with the state workforce agencies right now. Now, why would the state workforce agencies have anything to do with the PERM process? Well, this is one of the steps. So although the whole PERM process is through the Federal Department of Labor, one of the pre-recruitment steps or kind of pre-filing steps that has to be done is the employer must always post a job order with the state workforce agency, and that has to be posted for 30 days. So this is done before the PERM can be filed. But starting last week, and this was not just one state workforce agency, but multiple of them, they must be all using a similar system, but they're all experiencing a technical glitch right now. So you can't even log in as an employer to post a job order. So if you are in the recruitment steps, you've posted the newspaper ad, you've posted on your company website, or done your other 3 steps that you have to do, the notice of filing, the job order is one of those that is mandatory, has to be done for 30 full days, and then you cannot do it during the 30 days prior to filing your PERM. So if you can't even log in to post your job order, that means your PERM application filing date might actually be delayed if you have not filed yet and the job order has not already been posted. So just keep that in mind. Unfortunately, you've already been experiencing delays with getting the prevailing wage determination. Now this is just one more delay that you may have to face before you can even file the PERM. We don't know how long this is going to last, but the American Immigration Lawyers Association is aware of it and is trying to get more information on it. Hopefully that will be cleared up soon, so we won't see too much of a delay in people being able to file their PERM application. Also, speaking of PERM, and this also impacts H-1Bs and LCAs and E-3s, we have new prevailing wages that went into effect July 1st. Can you give us an update on that?
As of Friday, it was a Canada Day gift from USCIS and the Department of Labor. So yeah, every year annually, the DOL will release data, prevailing wage data that's reflecting the average wage for a given profession in a given locality. And so for immigration purposes, this data is typically used to set the floor at which you have to pay your immigrant workers or any immigrant worker, any alien worker, you have to pay above whatever this prevailing wage might be. So for employers, for those who are going forward with LCAs and maybe PERM certifications, you're likely going to see an increase in the wages that are coming back. For those new PERMs, any PERMs that are currently in process, or I should say any prevailing wage determination requests that are already in process, DOL will automatically pull forward these new numbers. Now in terms of LCAs, if you filed an LCA, don't worry about these new data points. Now if you're filing an LCA today, of course you want to follow the new wage guidelines, but if you have one in process, you don't need to worry about that being invalidated or anything like that. And then lastly, with these new prevailing wage levels, the DOL also identified a few new SOC codes. These are used to more accurately reflect the positions that employers are hiring for and the wages in those positions. One particular one is data scientist. And so, for instance, if maybe this is a new one, previously I think a lot of attorneys were filing for what you would maybe call all computer occupations other. And so if you were using one of these catch-all SOC codes, it might be in your interest to maybe dig down, take an extra look, and make sure that there isn't a new SOC code that's been created for your specific position.
All right, and as if we don't have enough things to worry about, USCIS created this new ability for people to pay their filing fees by credit card. This is specifically for applications and petitions that are filed at lockboxes, such as the I-129 or I-140 form filed in regular processing. They go to lockboxes before they end up at a service center in many cases. And so you had this option of adding this form, this G1450 form, filling out the credit card information and signing that, and having USCIS actually charge the filing fees to the credit card instead of submitting paper filing fee checks, which sounds great. But all of a sudden they started rejecting these credit card payments, and then that causes the entire filing to be rejected. So what it seems to boil down to is kind of 2 separate issues. One of them is when the premium processing and the regular processing filing fees are all included in one form. They're saying that no longer will they accept combined checks for these filing fees, so they won't accept a combined credit card payment when you're adding premium processing. So they seem to be just rejecting the whole application instead of just rejecting the premium. And then the other issue is all of a sudden they're rejecting it, saying it wasn't properly signed. This seems to be situations where it was a scanned copy of an original signature, which is allowed under the COVID guidance. We've been using scanned signatures for almost 2 years now. All of a sudden, for this particular form, they're not accepting them. And this is a real problem for cases where there's a deadline to file, like H-1B cap cases or I-140s where the PERM is expiring. So the American Immigration Lawyers Association is aware of it. They've reached out to USCIS to try to figure out why these rejections are happening, and then also to work to get these applications resubmitted based on their original filing date, because if you end up remailing it, they normally will go by the new filing date, which could be too late for cases that are involving a deadline. So hopefully we don't see this in our office because we use paper checks still. We're a little hesitant in trying new things before they've been vetted properly. But hopefully none of our audience is experiencing this, but if you do, someone is working on it and they're trying to get that resolved. So those are your updates for this week, so we can go ahead and get to some questions.
I saw one that popped up, and I get this question a lot from Sam on Facebook. He was essentially asking, I've already received my green card approval, now can I switch to part-time work, even though his green card or her green card might have been filed for full-time work? The answer to that is absolutely, positively, no questions about it. Once your green card's approved, you are a lawful permanent resident. And the way I think of it, you can work for any employer in any position in any locality. As long as it's legal, you have no problems whether it's full or part-time. So absolutely, if you want to take a part-time job, that's well within your rights.
Krishna has a very common question. Why is USCIS not releasing the second quarter data? As you all know, we got the first quarter data on the I-485 inventory, how many applications each service center has been processing versus the National Benefits Center. That first quarter data did not look great. And that's why we started asking you to send your letters to your congressman and your senator, as well as the ombudsman office, to get them to increase their rate of adjudication so that we can make it through all of these visa numbers that we have available this year and not waste them. Now, the second quarter data should have come out by now. It usually comes out in mid-June. We're now into July, and it's still not available. Now, is there something behind that? We just don't know if they're holding on to that data for some particular reason. I kind of have a feeling they're out there approving a lot of stuff. You can see that by how the ombudsman is saying we can't give you real-time updates on what's going on with these cases and whether the underlying basis has been transferred. I don't even think USCIS can keep track of it all. So maybe that's what's going on, is that it's just really hard for them to bring all those numbers together after they've been so busy and trying to get these cases done. That's the only thing I can think of. Hopefully it's a good sign that they've adjudicated a lot more applications in the second quarter than the first quarter, but we don't know. Will it be enough to get through all of them? Are we going to have wasted green cards again this year? Unfortunately, too soon to tell, but I don't like the fact that they're not sharing that data.
So Mina from YouTube asks or says that they did a downgrade in October 2020. They've already received the advanced parole and the EAD. They did an interfiling a little bit less than a month ago, and they still haven't received a 485J receipt notice. Any thoughts or advice? My first thought is that delay is pretty typical. I would say maybe 4 to 6 weeks is what you might want to expect. But nothing might hurt if you wanted to send the 485J again. I would say as long as it's from the same company, you shouldn't have any problems. The government won't look at it weird that you sent a second one after the first one. Maybe the first one got lost on an officer's desk and never got receipted. Rather than wait on nothing, why not send another one? Again, it doesn't cost anything to file the 485J, and there's nothing wrong with maybe having two out there. I would just make sure that it is from the same employer. You're not putting 2 or 3 different employers out there to carry you forward. So you shouldn't have any problems there. My biggest advice is just, it's a waiting game. I know people don't like to hear that, but I would say give it another 2 to 3 weeks before you hear anything. Maybe you can try the EMMA system, but this 485J process with USCIS is pretty new, so they themselves don't have much guidance to go by. And so it is a practice. This is the practice of law. And so all you can do is really try your level best. Wait a few more weeks. If you don't see anything, maybe try sending it again.
RV says, my EB2 485 refile has been approved and the green cards have been received. Congratulations. But the EB3 downgrade 485s from October 2020 are still pending. Do I need to send any withdrawal letter? You could, but I don't think you have to do that. What I've been seeing in my cases where I filed a second one and the second one has been approved, shortly thereafter we get either a notice saying that the first one has been administratively closed, or a denial notice saying we've denied your first 485 because we see you've already gotten approval, so it would serve no purpose. So I would probably just let them deny it or close it on their own and not bother with a withdrawal. If you really wanted to, you could send a withdrawal if you wanted to.
Sachin asked, and I think I get this question every day, my priority date's sitting in early 2015. What are the chances of my priority date being current this fiscal year, maybe next fiscal year? I wouldn't hold much optimism for this fiscal year. I mean, that ends in about 2 months. But I would be pretty optimistic for the next fiscal year. So fiscal year 2023, I wouldn't be surprised if it does creep into early 2015. So just maybe you can carry that optimism forward as well. But right now, I don't foresee it next year. I would, if I had to bet, I would probably say it would be there.
Manoj has a first-time H-4 EAD, and the U.S. Postal Service says the card has been delivered, but he didn't receive it and wants to know what are the options. Yeah, unfortunately, we do see this from time to time. Our experience has been when USPS says it's delivered, USCIS says, not our problem. So they're going to treat it as if they did their job and you must have lost it or something like that, which means you have to refile it, or you can work with the Ombudsman office to get them to see that you never actually received it. I'd probably do both. Unfortunately, with refiling it, it does mean the filing fee again, $410. So I understand it's not a, there's definitely a cost involved there. But you may find that ends up being the faster route compared to going through the Ombudsman and trying to wrestle with USCIS customer service to get them to reissue it, because a lot of times there is no customer service right now. It's like talking to a brick wall.
Pranay, excuse me, we're asked, will a job change, I'm trying to find the exact question here, recently filed the 485 under EB2 last month. They're planning to relocate from LA to the San Francisco Bay Area. Will that move have any impact on the 485? You would want to look into the file and see, what the PERM speaks to. But generally, that's not going to impact your 485, generally. Now, when you're filing the 485, when you're filing the I-140, there is a specific location that job is tied to. Whatever you're doing between now and the approval of the green card, wherever you're at geographically, to me doesn't necessarily matter. Because when you're filing the I-140, when you're filing the 485, what you're saying to the government is, once you finally approve me, that's where I'm going to go work, in that position. So if you're going to transfer from LA to San Francisco on your H-1B, that's completely fine. But at the 485 stage, you need to be willing to say to the government, it is my intent to go work in that job in LA. You do need to do the H-1B amendment to make sure you can take the job up there, and of course file your AR-11 to get the mailings updated, but you do need to be prepared to go to the government and say, it is my intent to go work in the LA position.
Arzu wants to know, what's the suggestion to file the I-140 and 485 all together or separately if my priority date is current? So if it's an I-140 that can be filed in premium processing, right now I'm filing those separately generally if the person's status will continue for a while and I'm comfortable that the date will continue to be current. Because if you file them together, there's that 485 is getting routed to Texas or Nebraska and getting stuck there, getting delayed, versus filing just the I-140 by itself, getting that approved, and then filing the 485. The 485 is going to the National Benefit Center. We're seeing some of those approvals in 63 days for the whole green card process, versus Texas that we're just now getting approvals from October 2020. So I think there's a lot of benefit. Yes, you're delaying your 485 filing by maybe 2 weeks, but a 2-week delay to save 2 years in processing time is well worth it.
Sri Ram on YouTube asked a question. We have an article on our website about this too. If you want to Google Reddy Neumann birth certificate, you can find a good article and some templates that you can use for documentation. But they asked, I submitted as a derivative applicant. My birth certificate doesn't have my name on it. I haven't submitted any secondary evidence. Will I get an RFE for this, or can it be approved? I would be willing to bet that you'll get an RFE, but it's not an RFE that should cause you any concern. If you don't have, the perfect birth certificate with your name on it, I'm assuming you might be Indian born. You can use doctor's records, your PAN card, there's an acronym that's escaping me right now, but there's a number of documents that you can have. Essentially anything that would come from a government agency that has your name and date of birth on it, that should be good enough. You can get affidavits from anyone who's pretty much not your mother or father or grandparents, and that should be fine enough as well. Anything else that you might think on birth certificate issues? That's pretty straightforward. Yeah.
Sue wants to know, his priority date's December 2013 and he downgraded in October 2020, but then moved to a different company. New company has not started the PERM yet. And he asked, do you suggest I go back to my old employer for EB2? Well, if your new company hasn't started the PERM yet, you're looking at probably 18 months to 2 years to getting to the point of having that PERM approval to be able to either file another 485 in EB2 or transfer the underlying basis from your pending EB3 485 to this new EB2 I-140. So if there's any option of going back to the old employer, you may save yourself 2 years of waiting for the green card, so I think it is well worth it.
There's a question, and it's similar to one that was addressed earlier, but the gentleman or the gentlewoman asks, once my green card's approved, can I take, I think it's passive income from YouTube, social media, things like that, things that are outside of your PERM or maybe outside of your green card application. Now, I'm going to say this, as long as your green card is approved, you can do anything that you want. As long as it's legal, as long as you're paying the taxes on it, you shouldn't have any concern at all with whatever employment you might be engaging, whether it's self-employment, sponsored employment, maybe these YouTube things, or going to work for 2 or 3 employers at the same time. No problems at all.
Mochi says, my wife got the H4 approved after 410 days, and we filed the H4 EAD. What is the approval time for the H4 EAD in 2022? So I'm not sure if you filed them together or separately. If you filed them together, they normally do approve them together. And if you did file them together, the fact that you, unless this is the initial H4 EAD, you may be eligible for the automatic 540-day extension if you've now got your H4 extended and you have the receipt for your EAD, but that's only for renewals. If this is the first time application or you filed the H4 EAD after you got the H4 approval, they're still taking, I think, 8 months to process just the simple H4 EAD by itself. So it's definitely not a fast process still.
Sumant asks a pretty common question from YouTube. Will USCIS adjudicators, will they adjudicate my green card with a successor in interest receipt, or will they wait on that successor in interest petition to be approved? They will wait on that successor in interest petition. I'm assuming that you mean the I-140. They will wait for the I-140 to be approved before they would adjudicate the GC. The I-140 always needs to be approved before they will approve the GC. And so, yeah, you will wait for the successorship and interest petition to be approved. Now, you can likely go forward with premium processing on that petition. I would say if you haven't filed it yet, go ahead and file it in regular processing, get the receipt notice, and then file the upgrade. But if you have the receipt notice in hand now, go ahead and do the upgrade. It's just going to get you that approval in hand that much faster, which means your green card is going to be adjudicated that much faster.
Shilpa has a downgrade pending as well as the EB3 I-485 application. The EB3 I-140 petition was upgraded to premium back in May, but still no result on that. And the USCIS is saying it's on hold for a security check, and wants to know the option for proceeding with a refile in EB2, and is the reason for the delay based on just the fact that they're trying to get that PERM document. And should I do a Freedom of Information Act request? So usually if they're trying to get the PERM document, they usually won't accept the premium processing in the first place. And if they do accept it, they usually don't say it's on hold due to security checks. The security check is usually something different going on there that could be quite a while before they can approve that I-140 petition. When you already have an I-140 petition approved in EB2, you may be better off refiling the 485 in EB2, assuming you've maintained your non-immigrant status. But you may want to talk with an attorney about that security check issue, because that can definitely take some time. And maybe, I don't know if you've had any recent experience with security checks on I-140s.
I haven't, no.
Yeah.
I don't think I hesitate to say never, but I've never heard of a security check on an I-140.
Yeah, when I've dealt with it, it's kind of just their blanket, we're not going to tell you anything, but we're looking into things. And it takes quite a while for them to do that, and they'll eventually refund the premium processing because they'll say they won't be able to do it in premium. So definitely want to get more information about any kind of background of the company or things that may have triggered that security check.
Rod from Facebook, March 2012 priority date, did a downgrade back in 2020. Was sitting in Nebraska, did an interfiling in 2022. They've got the EAD and the AP approved. They're still waiting on that 485 approval. They ask, should I refile an EB2? My first question to you would be, do you have the 485J receipt notice that shows that they've accepted the interfiling to the EB2? If so, I would probably tell you, you don't need to refile from a legal perspective. Tactically, it might get you the approval faster, but it's going to cost you a few $1,000s to do so. For me, looking at what you've told me, it seems like you're sitting in the EB2 line and you're just waiting for it to finally come to that officer's desk and give you the stamp that you're approved. Should you refile? I don't necessarily think so. Is there anything wrong with having two 485s out there? No, but you've done an interfiling which costs you $0. Doing a refiling is going to cost you a few $1,000s, and you're not likely going to see any real benefit from doing so. So in that regard, you probably shouldn't.
Akala Prasad says, I submitted my medicals with the 485 back in November 2020. Are these medicals valid for 2 years until November 2022? So the medical is valid for 60 days in order to file the application. So I'm assuming that the civil surgeon's signature was within 60 days of filing. Once you file, it is valid for 2 years from the civil surgeon's signature, not 2 years from the date of filing. So it may actually be less than November 2022, but expiring sometime this fall. Yes, it is valid for 2 years from the date of the civil surgeon's signature.
Narayan from YouTube asks a pretty common question. We filed the 485, the 765, the I-131 after the I-140 was approved in January 2022. Priority date is current. The biometrics were done in March, so a few months back. After that, nothing has happened. They ask, is this normal? I would say this is as normal as it possibly can get. I hesitate to give you how long it may be before you finally get that approval. From what you said, I don't know if the 765 and the I-131 are approved yet. That doesn't mean anything in terms of when they'll approve the 485. But right now, I would just say you're in the normal waiting game. It could take, like Emily said, 60-something days. Could take 60-something months. Unfortunately, that's just the nature of the game. I hate telling people you just have to wait, but I guess they say patience is a virtue for a reason sometimes.
Sumant says, will USCIS adjudicate the green card with a successor in interest receipt, or do they wait until the successor in interest petition is approved? I need to include the successor in interest receipt along with the interfile, since the EB2 I-140 has the old company name. So in the event of a successor in interest situation where your EB2 I-140 has the old company name and your company is filing an amendment in order to document that it is the successor in interest, they do have to have that successor in interest I-140 amended petition approved before the green card can be issued. So they are going to be re-looking into the labor certification, the education documents, the experience letters again, ability to pay all over again, plus making sure that that successor in interest relationship is there before they'll approve that I-140, and that has to be done before they'll approve the green card.
Prabha asks on Facebook, my PERM was just approved. I need my I-140 approved quickly so that the spouse can get an H4 EAD. They ask, should I file in regular and then upgrade after getting the receipt notice, or should I go ahead and file the I-140 straight in premium? If the PERM is valid, then yes, I would say go straight forward for premium processing. Do the I-140 with the I-907. You should get a receipt notice within about a week. Generally, I tell my clients for premium processing, you should expect the approval within about 2 to 6 weeks. That's just giving a little bit of a budget time in case an RFE comes. Gives us as the attorneys a little bit of time to answer it. Usually USCIS will give us the approval once we've responded to the RFE within about 15 days. So generally about 2 to 6 weeks is what you should budget if you are going forward in a premium processing case.
Poonam wants to know, is it safe to use the green card EAD or AP for travel? We're in the October 2020 batch, still waiting for the green card. Is there a chance of denial of the green card? So typically for employment-based adjustment of status applicants, the number one cause of the 485 denial is the I-140 denial if they were filed concurrently. So assuming that your EB3 downgrade, if you're in that situation, I-140 has been approved, there's generally not a lot that goes wrong with the 485 in a typical employment-based case. Of course, if you've got some kind of immigration violations in your history or criminal issues in your history or health issues where there's a ground of inadmissibility, those are not the normal cases. So you definitely want to talk to a lawyer before you rely on that AP to travel and rely on just the green card. But generally it is safe to use the advanced parole to travel once your I-140 is approved and it's a straightforward employment-based case.
Raj asks on Facebook, they have a priority date from 2009 and EB2. They departed the US in 2011. Seems like they've just come back now about a decade later. They're in H4. Can they still use that I-140 priority date of 2009? I would say absolutely. Even if the I-140 has been withdrawn, I would say from the very moment that the I-140 is approved, you are vested with that priority date. And the only way that you are going to lose that is if the Department of Labor goes and actively revokes the PERM approval on a finding of fraud or misrepresentation. So as long as you don't have that worry in the background, I would say 100% you've got that priority date from 2009. And then you follow-up questions, can the new employer file the PERM? Unless that first company, I'll call them Company A, unless they're willing to still give you that green card job, you will need a new employer to get their own PERM and their own I-140 for you. You'll be allowed to carry forward Company A's priority date from, I think, 2009. But you will need a new employer sponsorship PERM in the I-140 if you want to go forward with the 485 when you're ready. I mean, right now, you've got the priority date that's current, so I would say as soon as you can, get those things done so that you can file your 485.
Pavan says, does the 485 approval depend on country of birth? He's got a UK colleague who got the green card within 6 weeks of his biometrics. So other than, visa bulletin priority date standpoint, no, it generally does not, unless, there's certain countries like Iran, for example, that don't have good, ties with the US, and they check into those cases more detailed, but the typical India versus UK, there should not be any difference in the adjudication time other than the time you waited to file the 485.
Two similar questions. Nilesh on YouTube asks, priority date June 2015, I'm thinking a new employer is filing a PERM in February of this year. They ask, I'm kind of reading between the lines, once that PERM is approved, can they file the I-140 in both EB2 and EB3 premium processing? Now, without having seen the PERM, I can't answer whether you can go for both. Let's assume you can. Yes, you can file the I-140, EB2, and EB3. I would say that as long as the PERM is valid, you can do both of those in premium processing at the same time. So on the same day, I would maybe put them in two different packets, but you can send them both in premium processing, and that shouldn't be a problem. And let's maybe follow it up with one more similar question, Emily. Arun asks, they did a refiling for an I-140 premium processing early last month. When can you upgrade to premium processing? I would say whenever you get the receipt notice, I would feel confident as the attorney with filing the premium upgrade. Now, the worst that happens, they reject it, they send it back to you, you lose the money that you paid FedEx to send it to USCIS, but they don't put a black mark on your case, nothing like that. When I get the rejection, I take it, I ask my team to put it back in the packet and send it right back to USCIS, and I would say 85–90% of the time they're going to take it on the second or third bite of the apple. Right now, we don't have any cases that are being rejected, and so right now I think USCIS is good to take these refiling premium processing requests. So go ahead and do it now as long as you've got the receipt notice in hand.
PR says my EB2 got approved. I'm assuming this is the 485, and the EB3 485 was denied. Then I got a letter saying to return the EB3 EAD and AP to the local USCIS office. Is this expected? Do I get any acknowledgement after return? I wouldn't say it's normal, but it makes sense. We do see this from time to time, just in general in the event of an I-485 denial. I have not seen it in the case of a denial where the person received the green card through another filing. But I don't see any problem with you going ahead and returning that to the local office. As far as whether you get any acknowledgement, I doubt it. Not that I have seen, but you don't really need it for anything. Just keep copies of whatever documents you sent to them. But yeah, go ahead and send those in, not a problem.
So this is from Wahid on YouTube. It says, the party date is May 2015, EB2 India. What are the chances? I think he means what are the chances of the party date being current? I would say next year I would have some optimism, next fiscal year, so fiscal year 2023, I would be optimistic. This year, not so much. But I said earlier, if I was willing to bet, I would think your party date next year would be current.
Ralph says the case portal was updated June 2nd, saying that they're sending an interview for the 485, but it's still the same status today. Is there any way to expedite the interview? No, there isn't, and there's not really anything you can do. And the amount of time it takes from the time they say they're scheduling you for an interview to the time you actually receive the interview notice varies drastically depending on the different field offices. So sometimes we may get the interview notice within 2 weeks of that online case status. Sometimes it may be 2 months, sometimes even I've seen 6 months. Really just depends on that local office, but there's nothing you can do to trigger them to issue that notice. The delay is typically because they don't have any appointments available, either because they're trying to space them out due to COVID, or they don't have officers available, or they have too many cases.
Victory asks on YouTube, party date February 2015, both EB2 and EB3 are approved with the same employer. Any chance of being current, and do I need to file the I-140 again? I would say this year, maybe it creeps into early 2015. I wouldn't be optimistic. I think next year, given your priority date, I would be optimistic in fiscal year 2023. Now, I'm not sure what you mean by do I need to file the I-140 again. I would say no. You've got from company A, EB2 and EB3 I-140 approvals. For me, there's no need to file any I-140 again. As soon as your priority date comes current, use that I-140 approval, file your 485.
Sandeep says, my 485, 765, and 131 all went to the National Benefit Center, but then the 485 got transferred to Texas. In the meantime, the EAD and AP were approved at the NBC. What are the chances my application moves back to the NBC? They should be moving it back to the NBC. I guess the better question is, when might that happen? And that's anybody's guess. But as of the last several months, USCIS policy is that all employment-based 485s are processed at the NBC or the field offices. It's pretty rare nowadays for them to be transferred to one of the Texas or Nebraska Service Center and then not later be transferred back. The only time they would keep it at Texas or Nebraska generally is if that officer happens to open up and send an RFE for something that's missing. Now it's going to be stuck there from what I've been seeing. But otherwise, it should eventually go back to NBC.
From VS on YouTube, where asks, what does it mean when customer service says biometrics has been applied to your case? For me, that can mean kind of one of two things. One, it means that you went in, you had the biometrics done, and it's been applied to your case. Or if you've maybe done biometrics on a different case, so maybe it was your H-1B and you have a 485 pending, they'll take the biometrics from a previous case. I'm not sure about the time span that they're allowing right now, but they're reusing biometrics from different cases. And so that's likely why it is that you're seeing what you're seeing there.
Nylesh says, I have an EB2 priority date of June 2015. My employer filed for the PERM in February of this year due to a job code change and wants to know, should I file the I-140 in both EB2 and EB3 in a premium process, and can I do this concurrently? So you definitely can do that, especially nowadays because the PERM that you're getting is through the email. So it's not so much the blue paper that's been such the problem of getting the second filing done in premium processing. Is it a good idea to do that? There's definitely no harm in doing it other than the extra work and if you're going to pay extra fees for that process. But is it likely that EB3 is going to jump ahead again? I don't think so. I mean, I know a lot of people are jumping out of EB3 and back into EB2, but that's because EB2 has more numbers available than EB3, because EB2 gets the spill down from EB1 that aren't used. And then, of course, this year we have lots, every year we get some spill down, but this year we have a ton of spill down because EB2 got They're 28% of the extra 140,000 green cards that are going to all go unused in EB1 and flows down to EB2. Then all the rest of the world in EB2 extra flows to EB2 India. None of that happens for EB3. So I would be surprised if EB3 jumped ahead again like what happened in October 2020. But if you wanted to be prepared for that, just in case, yeah, absolutely. I don't see any problem with filing the I-140 in both categories.
Sanjay asks on Facebook, can I upgrade from EB3 to EB1? Currently now in L1A. I would say yes. Now, upgrade, probably not the word that I might use. It might cause some confusion. What I would say is that you can get an I-140 approved for you in EB1. You'll keep your EB3 priority date, no problems at all. I would say generally, if you're qualified for an L1A, you're probably going to be qualified for an EB1. So speak with your attorney, speak with your employer. I don't see any problems with you using what you're calling an upgrade from EB3 to EB1. Company who you have the L1 with needs to sponsor you, but if you're qualified for the L1, I think you would be qualified for the EB1.
Pavan says, do you have any help or info around the lack of Dropbox appointments in India? There's lots of appeals discussing it on Twitter, but nothing has improved. Yeah, not great information, but kind of my sense from the AILA conference that I was at in New York recently, although all of the posts, the consulates are encouraged to utilize the Dropbox and told that they do have that authority to use the Dropbox and avoid the interviews. On the ground, the consulates kind of get to control it themselves, so they don't have to do Dropbox, and they get to choose how much they're going to use the Dropbox. And it doesn't seem like they generally like it. So that may be part of the issue, but the bigger issue is that the consulates are not back to their full pre-COVID levels. They don't have the officers that they used to have, and according to some people with inside knowledge, it may be 10 years before they get back to where they were in terms of number of consular officers and the ability to handle the load that they were handling pre-COVID. So unfortunately, I think we're going to be continuing to see lots of difficulties in getting visa interview appointments and also shortages of Dropbox appointments for quite the foreseeable future.
Sam asks on YouTube, they have 11 months left on their H1 6-year limit. Prevailing wage for their PERM was submitted this week. They ask, what are the chances of getting the PERM approved within this time? And then what options are available if it doesn't get approved? So I would say you're really pressing, and I think right now our general is 10 to 14 months from start to finish. That includes prevailing wage determination and DOL's processing of the actual PERM filing, and so you are running it pretty close. First thing I would do is check in to see if you have any recapture time available for you. So if you went and you took a long vacation or anything like that, anytime that you're outside of the United States, you can recapture, and so you might be able to add on to those 11 months that you've got. Another option is if you want to stay in the United States, you could consider an F1 change of status, study for 6 months or whatever it might take to get the PERM approved, and then do another change of status back into the H1B. Or you depart the country, and once the I-140 is approved, you file for a consular processing of your H1B extension, and you come back in that way.
Raj has a priority date of EB2 in August 2013. He got his I-140 approved recently, but the priority date was wrongly given. Yeah, we're seeing that right now.
I have an article on our website.
Yeah, exactly. So the attorney emailed USCIS, should I wait for the corrected I-140 or send my 485 petition ASAP? Yeah, check out the article on rnlawgroup.com on that. I would not wait for it because it may take months to get. But when you get the 485 filed, you've got to make it clear to the officer that this is the correct priority date. Please don't reject it. Put it in a separate envelope, inside an envelope with all kinds of notations on it so that you don't get it kicked out in the mailroom.
Kumar asks on YouTube, EB3 I-140 is still pending. Do you think requesting premium would help my case? Now, I don't have any background facts about your I-140. If it was one that you filed within the last 6 months, you're in a normal wait time, maybe even in the last year. It's pushing it a little bit, but that is kind of the normal processing time with USCIS. If it was one of these cases you did back in October 2020, I would say without question, try to do the premium upgrade request. Honestly, your case file might have just been lost on an officer's desk. Doing the premium is going to kind of allow that cream to rise to the top. I really never have an issue with doing premium processing. I don't think that USCIS looks at the case in any more intense way. It's just going to get you the approval that much faster. Yeah, it costs $2,500 to get it that much faster, but I think that's going to get you, going forward with the premium, it's going to get you the result that you want. I'll say that.
PB Music says he interfiled back to EB2 from EB3. Both I-140s are approved. Priority date is 2011. His expedite request was denied, but his biometrics are done, got the E80 AP. What can I do now? Should I send the medicals again? You know, once your I-140 is approved, you've already submitted the medicals, assuming they haven't expired, you've got your biometrics done. Unfortunately, those are the only things that you have in your control and that you can do. You've done all of those, so I don't see any need to send in medicals again. At this point, it's waiting for them to process it. The Ombudsman's not helping. You could consider litigation. That's really our last option at this point to help people when everything is done in the case and you're just waiting for a decision and the amount of time it's taking is unreasonable. We've seen some success in that. There's a little bit of difficulties with litigating I-485 applications, but in certain cases it can work. So if you're interested in that, you can contact Stephen Brown in our office.
Wanderer on YouTube states that they filed the medical, or they replied to a medical RFE on an EB3 downgrade late last year in November 2021, but they don't see any case status updates. Do they need to send the medicals again, or is it still good to interfile for EB2 without medical RFE response? I would say if you submitted that medicals RFE, you're good to go. You don't really have anything to worry about in terms of doing the interfiling. Now they may ask for the medicals again, which isn't anything out of the ordinary. Maybe the medicals didn't make it into the file the way that they needed to or anything like that, but don't let maybe the lack of a case status update regarding the RFE in any way slow you down or prevent you from doing an interfiling onto the EB2. I say go ahead. You shouldn't have any concerns.
Addie has an EB2 priority date, and the labor was recently completed with his new employer. I-140 is in progress. He's currently in Canada and wants to know what he should do for the last step, consular process, or come back to the US on H-1B and do the adjustment of status. I'm a bit partial to adjustment of status. I would say 99.5% of my cases I handle are adjustment of status. I'm not a fan of consular processing. It's somewhat improved, but it's still just a hassle every time you send something into the National Visa Center because they're still having you mail in the documents, unlike family-based cases where you can actually upload them into that CEAC or CIAC system. But it's a very glitchy system, and you're mailing documents to the NVC, and then they respond back and say, we didn't receive these documents, or send them again. It's just a lot of back and forth in my experience, and you're waiting to get that interview, and that whole time you're outside the US. So if your goal is to get into the US as quickly as possible and be able to work while you're waiting for the green card, I would come back on H1 and do the adjustment of status. If you're not really, rushing to get back into the US and you have plenty of time, then, consular process is probably the simpler process because you don't have to worry about getting an H-1B first, and you can get that process going as soon as the I-140 is filed, really.
Arun Karthik asks on YouTube, their employer refiled the I-140 in June 2020 since they moved out of the company, so I imagine they might have withdrawn it previously. Now this I-140 that they refiled, the PERM, the labor is expired. What are the chances of getting the approval? For me, the fact that the PERM is expired has nothing to do with your chances of approval. As long as you can show the government that you used that PERM during its initial validity period, meaning you can show them the receipt notice from way back when, you'll be allowed to use the PERM, no problems at all. The only thing that I'm looking at now as the attorney is I want to look to see if the company has the ability to pay the PERM wage from the priority date of that labor certification. So if you're with the company for that 10 years, usually I never have any concerns about ability to pay. But maybe if you dropped off for 3 or 4 or 5 years, you do have a delta that the company has to cover by its tax returns. And so that's the only thing that I would be looking at as the attorney. And so as long as the company is what I'll just call financially healthy, as long as they're financially healthy, I would say your chances of approval are 100%. Now, sometimes the government does make a boneheaded denial, and so don't let that concern you if it does come, but you shouldn't really have any concerns. USCIS looks at 3 things. Do you have the education? Do you have the experience? And does the company have the ability to pay the wage from the PERM? If you can answer yes to those 3 questions, you should be answering yes, will I be getting this approval?
Annette from Facebook has the I-140 approved with a previous employer and moved to a new employer. They're filing the PERM in August. He wants to know which category should he go for, EB2 or EB3 with the new employer. Well, for the PERM process, I would generally recommend EB2 because that gives you the ability to file the I-140 in EB2 or EB3. If your PERM is destined only for EB3, your only option is EB3 once you get to the I-140 stage.
So I saw one question, I can't find it here. Okay, here we go. From Nikhil on Facebook, they got their I-140 approved, and then that same company who did the I-140 gave the individual a promotion. They asked, does the company need to start the GC process again? Can they still use the same priority date, etc.? I would say no matter what, you do keep the priority date. Now this is where it kind of comes to understand the practice and sometimes the art of immigration law. You filed your PERM for position A. In a normal scenario, and I guess I should say normal, a non-Indian, a non-Chinese scenario, you take that I-140 in the very same moment you file the 485. For Indians, you're going to probably file your 140 and then 10 years are going to pass. Your career is going to progress. You are going to be given promotions. So what happens with that I-140? If you really want to be boneheaded, you can make your employer get a new PERM. I would say that that's not necessary. Here's the way I look at things. I-140 was for position A. Yeah, it might be a lower level position. I would still say go ahead and file your 485 because what you're saying to the government is, it is my intent to go do that job with this employer. Now they do recognize sort of the backlog scenario and they do recognize career progressions. But what I would say is you need to be willing to go to the government and say, that's the job I'm going to take. Now, once they finally approve your green card, you can work for any employer in any position in any location you want. It's just about getting USCIS, making USCIS happy with your intent. And so, do you need a new GC process started for you? No. If you want it, go ahead. But I would say it's not necessary.
Kieran says he filed the 485 with an approved EB3 and the date was retrogressed. However, the green card got approved last week. He does have an EB2 approval with a previous employer that is still valid. Yeah, we're seeing this from time to time, and it could be one of 2 things. Either USCIS on its own transferred your underlying basis to the EB2 I-140 approval, even though you didn't submit anything and it was with an old employer, or they actually assigned you that visa number in EB3 when your EB3 final action date was current before it retrogressed, and then they just now got around to approving it. That's what happened in one of my cases. I went to the Ombudsman saying, hey, this isn't right. This person shouldn't have got the green card because their EB2 date wasn't even current at this point. And they confirmed, no, we actually assigned that visa number earlier when the date was current, and so even though it's retrogressed, that number was already assigned and the approval is valid. So it's probably one of those 2 things. I would not worry about it.
Felix asks on YouTube, can you let me know the basis for requests to expedite advanced parole to travel to India? As we know, stamping dates are hard to get. This person has a from what they're saying, I think their 485 has been pending for over a year, and I'm assuming that means probably their EAD and their AP has been pending for over a year. So I'm going to give you maybe a solution, but to address your question, what are the bases for requesting an expedited advanced parole? It's really going to be, and I hate to say it, a life and death situation. You need to be able to document it, and it's not just like, hey, my brother or my father is sick, I'd like to go spend some time with them. It really needs to be, if I'm not there within the next 48 hours, I'm probably not going to see this person ever again. That's generally what you're looking at. I don't know if you're looking at maybe fiscal or monetary issues, that's not likely going to push the case. Usually on these expedite of the APs, they're looking at, humanitarian concerns. Now, Stephen Brown in our office has been, from what I've gathered, has not seen a single defeat suing the government, litigating these EAD and advanced parole delays. From what I gather, he gets these in a month once he files the lawsuits. The government seems like they're pretty scared of these suits. They don't want it getting out there, so they approve them pretty quickly. That's not a guarantee, but if you are interested in maybe doing what you can to get this approval at ASAP, maybe you can contact Stephen Brown from our office. He may be able to help you out.
Rajni says local Minnesota field office is deadly slow. There's 2022 EB2s waiting for interviews scheduled. In her case, the interfiling was done and wants to know what are the chances for a 2020 filing without an interview. For 485s employment based right now, the majority of them are being approved without an interview. So it's kind of back to pre-Trump, where we were only seeing interviews in cases where there was a criminal issue or maybe a status violation issue, and they just need to get more information. From time to time, we just see a random interview that doesn't seem to be triggered by anything, but most of the approvals are not requiring an interview these days.
Rohit from YouTube asks, is it possible to file PERM I-140 through an employer different from our H-1B employer? If so, what are the requirements and any merits or demerits with this? Absolutely, without reservation, you can have an employer different from your H-1B employer file a PERM and file an I-140. The way I kind of present it to my clients is you can have never worked for a company, you can never have stepped foot in the United States, and a company can still do a PERM and an I-140 for you, no problems. What are the merits of it? Merits, I would just say it's an I-140 approval from a sponsor, and you can leverage that sponsorship once your parade date is current. No demerits. The only thing that I think about when I'm looking at what I call this kind of a future employment case, a case where you're not with the employer yet. The only thing I look at is, can the company pay your wage? And generally for me, that means, do they have an income of at least $100,000? Do they have assets of at least $100,000? By and large, most companies do. And so if you're going forward with the PERM and I-140 from a company who's not your own, you should be fine. You really shouldn't have any concerns.
Sam has 11 months left on his H-1B 6-year limit, and the prevailing wage was submitted this week for a new PERM, and wants to know what are the chances of PERM getting approved within that time? What other options do I have if it doesn't get approved? Unfortunately, assuming current processing times continue, it's very unlikely that you will be able to get the PERM approved when you just had the prevailing wage submitted, because that prevailing wage is taking 6 months. The PERM application is taking 6 months. That's not taking into account the time of recruitment steps that may have to be done after the prevailing wage is issued. So what can you do? You may need to look at maybe over the next 11 months taking some strategic trips outside the US, because you can recapture any time that you spend outside the US. That might buy you enough time to get to where you have the PERM and I-140 approved in order to extend beyond the 6-year limit. Otherwise, changing status to another type of visa that you might be eligible for, or exiting the US right before you hit that 6-year limit and waiting outside the US until your PERM and I-140 can get approved, so that you can then get the H-1B to come back once that is approved.
We have a question from Facebook from Bhushan. Can we respond to an RFE long after the permitted time window has expired? It seems like online the 485 application is still active. Right now there's a COVID policy that allows 60 days additional from whatever your deadline might have been. So if you're outside of that 60-day deadline, I as the attorney would say that case is probably dead. Maybe try to send the RFE response. The worst that happens is you get the denial that you're probably expecting anyways. And so to answer your question, can you respond after the deadline has expired? Yes. Does it need to be within 60 days? Yes.
Mender wants to know, can one work if the H4 and H4 EAD are pending? Does the 540-day rule apply? So the 540-day rule applies only in the event that you've got your H4 I-94 extended. So you may have filed your H4 and H4 EAD renewals, based on your spouse's H-1B renewal. Once your spouse's H-1B renewal has been approved, some people have been able to travel to Mexico, for example, and come back showing the spouse's H-1B extension approval and get an H-4 I-94 matching that new approval notice. In that situation, now you have an I-94 that's extended and you have a pending EAD, then you do qualify for the 540-day automatic extension.
Sandeep asks a very common question, but one that does need to be played carefully. Can I change my employer after getting the EAD approved, but before the 485 gets approved? The answer to that is yes, but you do need to see kind of where you are at within what I'll just call a 180-day window. If it's within 180 days of your 485 being filed, you need to wait a little bit of time. The company could pull that 485 job offer. If you've maybe done an interfiling, that's going to start your 180-day clock again. If none of those things apply, you're still going to need a 485J sponsoring employer. So say company A did your 485 and you're going to use your 765 to go to company B now. You're very likely going to run into the scenario where USCIS will want to see a 485J from this company B, showing that they're still willing to offer you a same or similar job as that company A.
All right, well, we are out of time for this week. Thank you all for joining us. Please remember you can sign up for our newsletter by going to rnlawgroup.com and subscribe to that. We send it out every Wednesday with all of the updates. And you can, of course, join one of our free daily conference calls. That schedule is also available on rnlawgroup.com.
Thanks, everybody.